It is another electoral reform driven by the Supreme Court. In a development that is expected to have a salutary effect on the electoral process, the Apex Court on Thursday held that the election of a candidate who has concealed his or her criminal antecedents during the nomination process should be declared null and void. The Apex Court ruled the suppression of criminal antecedents, especially relating to heinous crimes, by a candidate during nomination deprived voters from making an informed choice and created impediments in the free exercise of their electoral right. Such an election is liable to be rejected. Terming disclosure of criminal antecedents on part of a candidate as a categorical imperative, the bench held that non-disclosure would amount to undue influence and therefore the election is to be declared null and void by the Election Tribunal under Section 101B of the Representation of People Act 1951. The judgment was delivered in a case relating to non-disclosure of full particulars of criminal cases pending against a candidate, Krishnamurthy, who was elected as the president of a panchayat in Coimbatore district in Tamil Nadu in 2006. Krishnamurthy's election was challenged on the sole ground that he had filed a false declaration suppressing details of the criminal cases pending trial against him, and therefore his nomination ought to have been rejected by the returning officer. With the Supreme Court calling criminalization of politics absolutely unacceptable and an anathema to the sanctity of democracy, the question is, will this exert moral pressure on political parties to field candidates of integrity in the election fray? News Night Desk, DD News.